I've been in situations of disparity. I mean, I think the race team is going to focus on what they have to do this weekend, which I expect them to.
Jordan's 2311 Racing has just made a spectacular move that might change everything after NASCAR hit back at them once again. The racing governing body has filed a move to change its counterclaim, dismissing what it calls compelling evidence against the team co-owned by NBA legend Michael Jordan and current driver Denny Hamlin. This startling new revelation revolves upon NASCAR's accusations that they have unearthed devastating evidence within more than 200,000 pages of emails. These documents supposedly reveal 2311 Racing and Front Row Motorsports engaging in legal collaboration with rival teams. The timing couldn't be more significant, as both parties prepare for a December trial. What did NASCAR find? According to their lawsuit in the United States District Court for the Western District of North Carolina, Charlotte Division, the evidence includes emails, texts, and memoranda that NASCAR claims undeniably prove its charges against the teams and Jordan's business partner Curtis Polk. To understand the significance of these new claims, we need to look back at how this fierce legal battle began. The controversy began in October 2024, when 2311 Racing and Front Row Motorsports launched an antitrust action against NASCAR. The teams claimed that NASCAR engaged in anti-competitive and monopolistic conduct through its charter structure. This arrangement, which guarantees team seats in races and certain financial considerations, became the focal point of a violent feud when both 2311 and FRM refused to sign NASCAR's take-it-or-leave-it charter agreement for the 2025 season. Jordan's 2311 and Bob Jenkins' Front Row Motorsports did not execute the deal by the deadline of September 20th, 2024. Their denial triggered a series of legal tactics, which have now escalated drastically with NASCAR's recent complaint. NASCAR's charter system aims to provide teams with financial stability and guaranteed race berths. Essentially, charter teams receive assured participation in every race, as well as a predetermined income split. Both 2311 and FRM argue that the existing arrangement limits fair competition and allows NASCAR to control the sport. The teams say the funding model is unfair and does not provide them with a viable business framework. For comparison, according to the most recent charter agreement signed by other teams, NASCAR claims teams will get around 49% of the money from the new 7-year, $1.1 billion average per year TV rights deal. According to NASCAR's attorney Chris Yates, this is an increase from 38 to 40% in the last deal in March 2025. NASCAR retaliated by bringing a countersuit against the teams. They labeled 2311 and FRM as an illegal cartel, accusing them of knowingly violating antitrust rules by coordinating anti-competitive collective behavior. NASCAR singled out Curtis Polk, Michael Jordan's longtime business associate and 2311 co-owner, as the mastermind behind these initiatives. This accusation spurred Jordan to claim that the lawsuit had turned personal. Now, with this latest filing on April 18, 2025, NASCAR claims to have real evidence to back up these serious allegations. They are requesting permission from the court to alter their counterclaim to add passages from the previously found papers. What precisely is NASCAR claiming to have found? According to their filing, the materials reveal that 2311, Front Row, and Curtis Polk intentionally engaged into illegal agreements with other teams on a number of crucial concerns. These alleged agreements included determining how much cash they would receive from NASCAR and dispersing that compensation among the co-conspirator teams, with Jonathan Marshall of the Race Team Alliance serving as a conduit for these operations. The filing goes even further, noting, although its existing counterclaim more than adequately states a claim for relief, NASCAR seeks leave to file an amended counterclaim that includes excerpts of these recently produced documents because they confirm beyond any doubt that 2311 and Front Row reached unlawful agreements with each other and other teams, and that Curtis Polk was the ringleader. The sanctioning body claims Polk spearheaded efforts to determine team salary, boycott NASCAR races, interfere with NASCAR's negotiations with media partners, and reach illegal agreements. The teams responded quickly and forcefully. Attorney Jeffrey Kessler, who represents both 2311 and Front Row Motorsports, described NASCAR's new accusations as a pointless distraction and a desperate attempt to divert attention away from its own illegal monopolistic practices. NASCAR's response to our move to dismiss and their need to revise their counterclaim reveals the inadequacies in their arguments. Kessler noted that their original lawsuit aimed to make NASCAR more competitive and fair for drivers, fans, sponsors, and teams. These filings make no difference, and we look forward to presenting our position at trial. This letter demonstrates how the team saw NASCAR's counterclaims as a strategic legal move rather than a substantive charge with validity. An intriguing element in this legal drama is the club's attempts to collect financial information from other major sports organizations. In early April, 23XI and FRM proceeded to court to enforce subpoenas served on the NFL, NBA, NHL, and Formula One. The teams seek to compare their respective sports financials to NASCAR's model. According to their complaint, this information would allow plaintiffs to make a yardstick comparison between the other major professional sports leagues, where competition is permitted, and NASCAR, where exclusionary conduct has been employed to illegally retain a monopoly. The NFL vigorously opposed this request, arguing the following. The subpoena is based on the flimsiest of premises, that because plaintiffs are suing NASCAR, they can obtain by way of federal process financials, financial projections, research studies, analyses, and other highly confidential, proprietary, and commercially sensitive information belonging to almost every other major sports league in the United States. This battle for comparative financial data highlights the case's primary question. Is NASCAR's revenue-sharing scheme equitable when compared to other major sports? The team scored a crucial success in December 2024, when U.S. District Court Judge Kenneth Bell approved their motion for a preliminary injunction. This verdict allowed NASCAR to allow 23XI and FRM to sign charter agreements provided in early September, as well as sanction the transfer of charters each team intended to purchase from Stewart-Haas Racing. To get this injunction, the teams had to prevail in 4 areas. Likelihood of success. The judge determined that the section in the charter agreement releasing NASCAR from legal claims would most likely be deemed illegal. Irreparable harm. The judge acknowledged that drivers could leave the teams and sponsors might withdraw if they were unable to race as chartered teams. Equities balancing. The judge decided that the injunction would not affect NASCAR, but would cause severe injury to the teams if it did not exist. Public interest. According to the judge, NASCAR fans want to see all of the teams compete with their finest drivers and teams. Furthermore, the public is interested in protecting plaintiffs' rights to pursue legal claims in good faith, notably antitrust actions that seek to preserve the process of commercial competition. This verdict was appealed by NASCAR, and a hearing has been scheduled for May 9, 2025, in the United States Court of Appeals in Richmond. Jimmy Johnson, a NASCAR legend, has spoken out on what he believes the sport will look like after the legal dispute is resolved. During an appearance on the Business of Sport podcast, Johnson stated that he expects NASCAR to grow into a structure more similar to other sports leagues. So this year, we're going to Mexico City for the first championship points-paying event for the top series ever. They took one of the races to Chicago, and there's a street circuit in downtown Chicago. So as we look forward, and, there's some rumors about NASCAR someday selling a portion off and becoming more of a league, and we're all waiting and think that there's a real potential there. And as we become a league, that's when all ships in the harbor, I think, will rise more. Johnson believes NASCAR still has a long way to go before reaching the same heights as other American sports leagues due to the sport's gradual progression. Comparing the situation to recent changes in other sports, Johnson added, "And the more I dig in, the more I understand. This just happened in Formula One. This happened not long ago in the NBA. And I just think we're following the same trajectory, where it's going to become a proper league, and it has to evolve." NASCAR's primary defense against antitrust accusations is to challenge the definition of the market itself. They contend that limiting the market to only cup racing is too restricted for antitrust considerations. Instead, NASCAR maintains that the relevant market should encompass all motorsports, or even the whole sports scene. This distinction is critical because antitrust law focuses on whether an entity has monopoly power in a specific market. In contrast, the teams claim that NASCAR Cup Series racing is its own independent market. In his injunction ruling, Judge Kenneth Bell agreed that the availability of multiple sports in the U.S. does not indicate NASCAR's control over a major one, just as the availability of professional basketball and football did not prove the NCAA's monopoly over college basketball and football. So, what do you think? Does NASCAR stand a chance in this case? Are they going to beat 23-11 to the decision when the time arrives? Let me know your thoughts in the comments down below.